If I had known that the first 10 seconds inside that courtroom would decide the entire course of my life, I would have chosen my silence more carefully. But on that morning in downtown Chicago, I walked into courtroom 4B with nothing but a calm face and a case file I refused to open too early. My name is David Reynolds, and as I stepped through those heavy wooden doors, I could feel every eye in the room measuring me before I even took my seat. Melissa Reynolds was already there, sitting perfectly upright beside her attorney Laura Benson, dressed like she was attending a business meeting rather than ending a marriage. She didn't look at me right away, but I saw the faint curve of her lips as she leaned toward her lawyer and whispered something I couldn't hear, though I could guess the tone without translation. It was the tone of confidence, the kind that assumes the outcome is already decided. I took my seat slowly, placed my folder on the table, and did something that surprised even me in hindsight. I said nothing. Not a greeting, not a nod toward counsel, not even the smallest acknowledgement toward the woman I had been married to for nearly 9 years. The courtroom itself felt colder than I expected, the kind of cold that settles into your shoulders and makes every movement feel deliberate. Judge Alan Whitmore adjusted his glasses and scanned the room, his voice steady as he called the session to order, but I barely heard him. What I did hear clearly, however, was Melissa's whisper to her attorney moments before proceedings began. "He's unprepared," she said softly, just loud enough for confidence to replace doubt, and I realized then she truly believed it. Laura Benson opened first, as expected, her voice polished and precise, painting a narrative where Melissa was the structured one, the responsible one, the partner who had carried stability while I, according to her framing, had drifted into silence and detachment. She spoke about finances, about lifestyle differences, about emotional distance, each sentence carefully shaped to guide perception rather than truth. I remained still, hands folded, eyes forward, letting every word pass without resistance. Silence, I had learned, was not surrender. It was timing. Melissa glanced at me once during Laura's opening, expecting something, a reaction, a correction, maybe even frustration. I gave her none. Instead, I watched the judge, I watched the court reporter, I watched the rhythm of the room itself, because rhythm always tells you more than words do. There was a moment when Laura paused, perhaps expecting me to object or interrupt, but I didn't. I simply allowed her to continue building a case I already knew would collapse under its own weight. Melissa leaned back slightly, satisfied by what she thought was unfolding, her posture relaxing as if the outcome had already been signed in her favor before a single piece of evidence had been reviewed. That was the first mistake she made that morning, but it wasn't the last. As the judge turned a page in the case file, I felt something settle inside me, not anger, not urgency, but clarity. Because what neither of them understood yet was that I hadn't come to that courtroom to compete in noise or arguments. I had come to observe, to let every assumption reveal itself fully before I ever chose to respond. And as Laura Benson finished her opening statement with a confident cadence that echoed through the room, I finally understood how deeply they had misread the silence I had chosen, because silence, when used correctly, is not absence, it is preparation, and I was more prepared than either of them could imagine. The room had settled into a rhythm that belonged entirely to the prosecution of perception, not yet truth, as Laura Benson continued speaking with the kind of precision that suggested every sentence had been rehearsed to feel inevitable. She shifted from emotional framing into structured claims, referencing timelines of separation, financial independence, and what she described as a gradual breakdown of shared goals, while I remained in the same position, hands folded on the table, posture steady, eyes occasionally drifting to Judge Alan Whitmore, who was taking notes, with careful neutrality. Melissa Reynolds sat beside her attorney with a calmness that bordered on certainty, occasionally adjusting her posture as if she was already preparing for a judgment she believed would favor her narrative. At one point, Laura turned slightly toward the bench and emphasized the idea that communication between spouses had diminished long before formal separation, framing it as mutual distance rather than unilateral withdrawal, and I noticed how effortlessly the story was being shaped not by what was proven but by what was assumed. When she finished her opening framing, there was a brief silence in the courtroom, the kind that invites response, but I still said nothing. Instead, I allowed that silence to remain intact, and I could feel the subtle shift in attention from the attorneys toward me, as if waiting for resistance that never came. Melissa finally looked directly at me then, her expression carrying a mix of impatience and restrained satisfaction, as though my lack of response was itself confirmation of weakness. She leaned slightly toward her attorney and whispered again, this time with more certainty, and I caught only fragments of her tone but understood the meaning clearly enough. She believed the advantage was already secured. Judge Whitmore adjusted his posture, scanning both parties with a measured expression before signaling that preliminary statements were complete and that the court would proceed into initial questioning of context and evidence. Laura Benson immediately moved into structured assertions about financial organization, referencing shared accounts, asset classification, and what she described as discrepancies in contribution versus benefit, each phrase carefully chosen to sound objective while subtly reinforcing her client's position. I observed how the language of law can sometimes resemble the language of storytelling when used strategically, because both depend on framing more than fact in their early stages. When the judge asked if either party wished to clarify preliminary positions, Melissa spoke for the first time directly, her voice calm but confident, stating that she had prepared thoroughly and that she believed the facts would clearly support her case. She did not look at me while speaking, instead addressing the court as though I were already a concluded variable in the equation. I noted the phrasing carefully, because confidence in a courtroom often reveals more about expectation than evidence. The judge acknowledged her statement without comment, then turned briefly toward me, offering the same opportunity to respond, and for the first time since entering the room, every gaze aligned in my direction. I did not answer immediately. Instead, I allowed the moment to extend just long enough for the expectation of speech to settle fully into the room, because silence, when extended correctly, begins to change temperature. Melissa shifted slightly in her seat, perhaps interpreting my hesitation as uncertainty, while Laura Benson maintained a composed expression, though I could see a subtle recalibration in her eyes as she evaluated my continued refusal to engage. When I finally spoke, it was only to confirm that I understood the proceedings and had no preliminary objections at this stage, and then I returned to silence just as deliberately as before. That decision, simple on the surface, altered the rhythm of the room more than any argument could have at that moment, because it confirmed something neither of them had accounted for yet, which was that I was not participating in their tempo. I was waiting outside of it entirely, and that distinction, though invisible to most, would soon become the most important factor in everything that followed. The atmosphere in the courtroom shifted subtly as the proceedings moved from opening statements into structured questioning, and I could feel the transition not in words but in the way attention began to redistribute across the room. Judge Alan Whitmore leaned forward slightly, signaling the beginning of clarifications, and Laura Benson immediately adjusted her posture, ready to transition from narrative framing into procedural control. Melissa Reynolds sat beside her with a composed expression that still carried the quiet certainty of someone who believed the foundation of the case had already been established beyond dispute. When the judge invited clarification regarding financial context, Laura responded first, outlining what she described as the standard expectations of shared marital contribution, referencing income flow, household expenditures, and the perception of unequal investment over time. Her tone remained calm, but each sentence was carefully constructed to reinforce a single idea, that the structure of the marriage had been imbalanced long before legal separation was initiated. I remained still, hands resting lightly on the table, eyes occasionally shifting toward the documents in front of me but never opening them, because I had already memorized every page that mattered. As Laura continued, she introduced selective comparisons between perceived earnings and lifestyle maintenance, subtly guiding the court toward an assumption of financial disparity that favored her client's position. The judge listened without interruption, his expression neutral but attentive, occasionally making small notes that revealed nothing of interpretation. When Melissa was asked to clarify her perspective, she spoke with a confidence that was carefully measured, describing herself as the stabilizing force within the relationship, someone who had maintained emotional and logistical consistency while perceiving withdrawal from the other party. She did not raise her voice, nor did she appear emotional in any visible way, but the language she used carried certainty rather than uncertainty, as though she were recounting established fact rather than personal interpretation. I noticed how often perception becomes substitution for evidence in moments like this, where structured storytelling can temporarily resemble truth if left unchallenged. Still, I said nothing. That silence, however, was no longer being interpreted as neutrality. It was beginning to be interpreted as absence. Laura Benson seized that perception and gently reinforced it, suggesting that my lack of immediate rebuttal indicated either unpreparedness or acknowledgement of the narrative being presented. I observed the strategy without reaction, because recognition does not require participation. The judge then turned toward me once again, offering a direct opportunity to respond to the financial and emotional framing being constructed in the room. Every eye aligned toward my position, waiting for disruption, clarification, or defense. Instead, I simply acknowledged the court's point of inquiry and confirmed that I would address all claims in due course, maintaining procedural alignment without engaging substance. That response was brief, controlled, and intentionally incomplete, and I could see the shift it created almost immediately. Melissa's expression tightened slightly, not in concern, but in recalibration, as if she was adjusting expectations rather than outcomes. Laura Benson, however, showed the first sign of uncertainty, not in words but in timing, because her rhythm of argument depended on reaction, and reaction was no longer being provided. The judge noted my response and moved forward with procedural structure, but the dynamic in the room had already begun to change in a way that was not yet visible in rulings or statements. It was changing in pacing, in expectation, in the unspoken assumption that silence equaled vacancy. As the session continued, I observed each layer of testimony and framing with deliberate detachment, recognizing that courtroom advantage is often not determined by who speaks first or loudest, but by who understands when not to fill space. And in that space, slowly expanding between every claim and every assumption, I remained exactly as I had been from the beginning, present, observant, and entirely unreadable. The courtroom had settled into a procedural rhythm that felt increasingly deceptive, as if every participant believed they were operating within the same understanding of what was being built, while in reality only one of us was tracking the structure beneath the surface. Judge Alan Whitmore continued guiding the session through formal clarifications, shifting between financial disclosures and marital timeline verification, while Laura Benson maintained control of the narrative with carefully structured statements designed to reinforce consistency in Melissa Reynolds' position. Melissa herself appeared increasingly composed, her confidence no longer tentative but reinforced by the absence of resistance from my side, which she seemed to interpret not as strategy but as concession. When asked to elaborate on financial expectations, Laura introduced a more detailed breakdown of shared living expenses, credit distribution, and what she framed as long-term imbalance in contribution to household stability, each point delivered with measured precision that gave the appearance of objectivity even when interpretation was clearly embedded within it. I remained in the same position, posture unchanged, eyes occasionally shifting between the judge and the documents in front of me, but never engaging directly with any of the claims being presented. That absence of reaction had now become part of the courtroom dynamic itself, no longer seen as neutrality but as something closer to vacancy, as though I had nothing to bring forward that could alter the direction already established. At one point, Laura Benson subtly emphasized that no counter-documentation had been presented to dispute the financial framing, and I could feel the shift in attention as that statement settled into the room, because silence begins to take on weight when it is mistaken for absence of preparation. Melissa glanced toward me briefly after that remark, her expression carrying a restrained satisfaction, as if the structure of the case was now confirming itself in real time. Judge Whitmore made a note, then requested clarification regarding asset categorization, and Laura smoothly transitioned into discussing property classification and shared versus individual holdings, maintaining the same controlled cadence that had defined her presentation from the beginning. I observed how each layer of argument was being stacked not for immediate resolution but for cumulative perception, because in legal environments perception often matures into assumed truth if it remains unchallenged long enough. When Melissa spoke again, She added emphasis to the idea that she had been transparent throughout the relationship regarding expectations of partnership, positioning herself as consistent, while subtly implying that deviation had originated elsewhere. Her tone remained calm, but there was now an underlying certainty that suggested she believed the outcome was simply waiting to be formalized. I did not interrupt, nor did I correct, because correction at the wrong moment can validate the structure it attempts to dismantle. Instead, I allowed every statement to complete itself fully, even when silence made the room feel heavier than speech would have. The judge then briefly paused proceedings to review submitted materials, and during that interval I noticed something subtle shift in Laura Benson's posture, not in confidence but in pacing, as if she was beginning to sense that the expected reaction pattern was not emerging. Melissa, however, remained largely unaffected, leaning slightly back in her chair with the calm assurance of someone who believed the trajectory was already irreversible. When proceedings resumed, Judge Whitmore requested that both parties prepare for the next phase of evidentiary discussion, and as that instruction was delivered, I finally adjusted my position slightly for the first time, not as a reaction, but as a preparation. That movement, minimal as it was, did not go unnoticed. Laura Benson tracked it immediately, Melissa followed a moment later, and for the first time since the session began, the silence I had maintained was no longer being interpreted as emptiness but as containment. Because in environments where every assumption depends on visible output, the absence of visible output begins to suggest something hidden rather than something missing. And as the courtroom transitioned toward the evidentiary phase, that distinction became the first real point of uncertainty in a narrative that had, until that moment, been presented as already resolved. The transition into the evidentiary phase changed the atmosphere in a way that was not immediate in sound but undeniable in structure, as if the courtroom itself had shifted from storytelling into verification, and every assumption that had been built so far was now required to either hold weight or collapse under it. Judge Alan Whitmore adjusted his position and instructed counsel to proceed with submitted exhibits, his tone steady but more deliberate, signaling that narrative framing was now giving way to documentation. Laura Benson responded first, standing with the calm precision of someone who had already organized the evidence into a sequence designed to reinforce continuity, and she began presenting financial records, account summaries, and selective transaction histories intended to support the claim of imbalance within the marriage structure. Each document was introduced with careful phrasing, always emphasizing interpretation before detail, ensuring that the court received context before scrutiny. Melissa Reynolds remained composed beside her attorney, her posture relaxed in a way that suggested confidence had not yet been challenged by contradiction, and occasionally she would glance toward the judge as if verifying that the process was unfolding exactly as expected. I remained still, hands resting lightly on the table, eyes focused not on the documents being presented but on the rhythm of presentation itself, because rhythm often reveals intention more clearly than content. When Laura referenced shared expenses and contrasted them against individual contributions, I noticed how each comparison was structured to guide perception toward imbalance rather than simply present data, and yet I offered no interruption. Silence, at this stage, was no longer passive, it had become observational discipline. The judge examined each exhibit with measured attention, occasionally pausing to ensure clarity, while the courtroom clerk recorded every submission with mechanical consistency that contrasted sharply with the emotional framing being constructed by counsel. At one point, Laura Benson introduced a summary document that she described as a comprehensive overview of marital financial flow, positioning it as a definitive representation of the relationship's structural imbalance, and as she spoke, Melissa subtly nodded once, as if confirming alignment with the narrative being reinforced. It was during this sequence that I observed the first real sign of recalibration in Laura's cadence, a slight tightening in pacing that suggested she was monitoring not just presentation but reaction, or more specifically, the absence of reaction. Because what had been expected by this point was disruption, objection, or at minimum clarification, and none of those responses had occurred. Instead, every claim had been allowed to complete itself fully, which created a psychological gap that interpretation naturally attempted to fill. When Judge Whitmore briefly paused to review the documents more closely, I noticed Melissa shift her gaze toward me again, this time with less certainty than before, though still maintaining composure. Laura Benson continued speaking, but her emphasis subtly adjusted, moving from assertion toward reinforcement, as though compensating for something that had not yet manifested. I understood then that the structure being built depended heavily on my participation in resistance, because resistance validates framing, while absence of resistance forces framing to stand alone. As the judge concluded his review of the initial exhibits, he acknowledged receipt and requested that the next set of materials be prepared for submission, and at that moment I made the smallest adjustment in posture, opening my folder for the first time without yet presenting anything. The movement itself was minimal, but it altered attention distribution instantly. Laura Benson noticed first, her eyes tracking the folder rather than my face, and Melissa followed a second later, her expression tightening almost imperceptibly as anticipation replaced certainty. No one spoke during that interval, yet the silence had changed quality, no longer belonging to control but to expectation. Because in courtroom environments, what is withheld often begins to carry more weight than what is shown, and in that shift, the narrative that had seemed stable just minutes earlier began to show its first sign of structural uncertainty. The courtroom had reached a point where presentation no longer felt like introduction but escalation, as if every layer of evidence being introduced was not simply informing the judge, but quietly testing the stability of the narrative that had been constructed so far. Judge Alan Whitmore remained composed, his attention fixed on the sequence of materials being brought forward, while Laura Benson continued with controlled precision, transitioning from general financial summaries into more specific documentation that she described as supportive context for the claims already established. Melissa Reynolds sat beside her with a posture that still conveyed confidence, though I could now observe subtle changes in her focus, small shifts in eye movement that suggested she was beginning to track not only what was being said but what was not being answered. When Laura introduced the next exhibit, she did so with a slight pause, emphasizing its importance as a consolidating document intended to unify previous statements into a single coherent interpretation of financial and relational imbalance. The courtroom clerk accepted the file, and the judge reviewed it with measured attention, scanning through sections without revealing reaction. I remained silent, hands still resting near the open folder, not yet engaging, but fully aware that silence at this stage was no longer being interpreted as neutrality. It was now being interpreted as withholding. That distinction mattered because withholding implies possession. Laura continued speaking, but I noticed her cadence beginning to adjust again, not outwardly, but structurally, as if she was ensuring that each point reinforced the previous one more firmly than before. Melissa's earlier confidence had not disappeared, but it had shifted slightly into attentiveness, her gaze now moving between the judge and the documents with less certainty and more evaluation. When Judge Whitmore finally looked up from the exhibit and asked for clarification on one specific section regarding financial categorization, Laura responded immediately, but her explanation carried a tone that was now more defensive in structure than assertive in presentation. It was subtle, but noticeable in timing, as if the narrative was beginning to require reinforcement rather than expansion. I observed this carefully without movement, because courtroom dynamics often reveal their direction not when arguments are made, but when they begin to require support within themselves. The judge made a brief note and set the document aside, then requested that the next submission be presented. It was at that exact moment that I closed my folder slowly, the sound almost imperceptible, but enough to shift attention once again toward my position. Laura noticed immediately, her eyes tracking the motion before I spoke, while Melissa's posture straightened slightly, anticipation returning but now mixed with something less defined. I did not immediately present anything. Instead, I adjusted the placement of the folder and rested my hands on the table, allowing a pause to form without explanation. That pause extended longer than necessary for comfort, and in that extension, the courtroom began to recalibrate expectation. Because when nothing follows preparation, interpretation begins to fill the gap, and interpretation in legal environments often leans toward uncertainty rather than strategy. Judge Whitmore observed the moment without comment, but his attention had clearly shifted toward readiness rather than review. Laura Benson, sensing the change, attempted to proceed with verbal reinforcement of her earlier exhibits, but the momentum she had maintained earlier was no longer flowing as smoothly. Melissa glanced at her attorney briefly, then back toward me, her expression now carrying a restrained uncertainty that had not been present before. And in that silence, which was no longer passive but active, the structure of control that had been carefully built began to show its first visible signs of imbalance, not through argument or evidence, but through the simple absence of predictable reaction. The silence that had begun forming earlier in the courtroom was no longer neutral by the time proceedings resumed, because it had evolved into something more structural, something that influenced pacing rather than simply filling space between statements. Judge Alan Whitmore reopened the evidentiary phase with a measured request for continuation, his tone unchanged but his attention now noticeably more focused on the transition between exhibits and responses rather than the exhibits themselves. Laura Benson immediately resumed control of presentation, but there was now a slight shift in how she delivered each point, as if the earlier confidence required reinforcement through repetition rather than expansion. She referenced prior documents, again, linking them together more explicitly, attempting to strengthen continuity across financial summaries and interpretive claims, but the rhythm that had previously carried her arguments smoothly now required subtle pauses for emphasis. Melissa Reynolds, however, appeared to regain composure during this phase, her posture straightening slightly as she leaned into the perception that the structure of the case still favored her position. When Laura reiterated the interpretation of financial imbalance and relational disengagement, Melissa nodded once, more decisively than before, as if confirming that the direction of the argument remained aligned with her expectations. It was at this point that Melissa chose to speak again, addressing the court directly with a calm but increasingly assertive tone, stating that she believed the evidence already submitted clearly demonstrated a pattern of withdrawal and lack of contribution, framing her position not as opinion but as conclusion. Her words were carefully chosen, each sentence reinforcing certainty rather than inviting interpretation, and I observed how the courtroom responded not with agreement or disagreement, but with attention recalibrating toward her confidence. Judge Whitmore listened without interruption, his expression unchanged, but his pen paused briefly as she concluded her statement, indicating that he was noting not just content but tone and implication. Laura Benson followed immediately, reinforcing Melissa's statements by referencing specific sections of previously submitted documentation, effectively layering interpretation over interpretation in a controlled sequence designed to solidify perception before contradiction could emerge. I remained still throughout this exchange, hands resting on the table, gaze steady, not reacting to any individual claim, because reaction at this stage would have only validated the structure being constructed around it. However, I could feel the subtle shift occurring in real time, not in words but in pacing, because confidence that is not challenged begins to accelerate its own assumptions. Melissa, noticing the lack of response from my side, leaned slightly forward. Again, her voice now carrying a sharper edge as she reiterated that she had expected clarity, or rebuttal by this point in the proceedings, implying that absence of response was itself indicative of weakness. Laura did not interrupt her, allowing the statement to settle before continuing with her own reinforcement, but I noticed for the first time a slight misalignment in their coordination, as if confidence had begun to exceed verification. Judge Whitmore then raised a procedural question regarding the completeness of submitted materials, asking whether all intended evidence had been presented for consideration, and the question landed in the room with unexpected weight. Laura Benson responded affirmatively, but her timing was marginally slower than before, and that delay did not go unnoticed. It was at that moment that I finally adjusted my position and opened the folder fully, not dramatically, but with deliberate precision that immediately redirected attention. Every eye in the courtroom tracked the movement, not because of force, but because of anticipation that had been building without release. Melissa's expression changed first, subtle but visible, as certainty began to encounter uncertainty for the first time since proceedings began. Laura Benson's gaze fixed on the folder rather than my face, recalibrating her focus from argument to possibility. I did not yet speak or present anything, but the act of preparation itself had already altered the rhythm of the room. Because in environments governed by structured presentation, the moment preparation becomes visible without immediate execution, expectation transforms into instability, and in that instability, even the most confident narrative begins to reveal where it may no longer be fully in control. The entire courtroom seemed to hold its breath at the exact moment my folder was fully opened, not because anything had been revealed yet, but because the possibility of revelation had finally become undeniable, and that shift alone changed the way every person in the room was now interpreting silence. Judge Alan Whitmore's attention sharpened subtly, his pen no longer moving as freely across his notes, while Laura Benson adjusted her stance almost imperceptibly, her confidence now being filtered through caution rather than control. Melissa Reynolds, however, tried to maintain her composure, though the earlier certainty in her expression had begun to fracture into something more observational, as if she was now trying to anticipate rather than affirm the next development. I did not speak immediately. Instead, I allowed the moment to extend, not for dramatic effect, but because timing in a courtroom is never about urgency, it is about precision. Then, with measured calm, I reached into the folder and placed a single document on the table without sliding it forward, without presenting it as evidence yet, only making its presence visible enough to change the geometry of attention in the room. It was not the volume of material that mattered, but the specificity of its positioning, because every eye in the courtroom shifted toward it instantly, including Laura Benson's, whose earlier control of pacing now had to adjust to something she had not preempted. Judge Whitmore leaned forward slightly, signaling silent permission for clarification, while Melissa's gaze locked onto the document with an expression that had moved beyond confidence into cautious analysis. I finally spoke, my voice steady and even, not raised, not emotional, but deliberately clear, stating that the document in question was not supplemental but foundational, and that it directly addressed the financial and procedural assumptions that had been guiding the case up to that point. The courtroom clerk prepared to receive it formally, but I did not release it yet, because release without context would have weakened its intended effect. Laura Benson attempted to regain structural control by referencing previously submitted exhibits, but there was now a noticeable disruption in her rhythm, as if she was trying to reassert a framework that was no longer responding predictably. Melissa leaned slightly toward her attorney, whispering something brief, but I could see from her posture that she was no longer certain of alignment between expectation and outcome. Judge Whitmore requested that the document be submitted for review, and only then did I slide it forward across the table with deliberate control, allowing it to reach the center of evidentiary focus. The judge took it without comment, scanning the first page with slow, deliberate attention, and for the first time since proceedings began, I saw a measurable pause in his reading rhythm, not confusion, but recalibration. Laura Benson's expression tightened slightly as she tried to identify the structure of the document before its contents were fully absorbed, while Melissa sat more rigidly now, her earlier ease replaced by concentrated focus. I remained still, because at this stage explanation would have diluted impact, and impact in legal environments is never created through volume but through inevitability. As the judge continued reading, the atmosphere in the courtroom subtly shifted from procedural observation to interpretive uncertainty, because what had been presented earlier as a complete narrative was now encountering a structure that did not align with its assumptions. Laura finally asked for a brief recess to review the material more thoroughly, but even her request carried less certainty than before, and the judge agreed after a short pause, noting the necessity of ensuring full comprehension before continuation. As the courtroom prepared to temporarily adjourn, I observed something important that did not require words to confirm, which was that the control of the narrative had shifted away from those who had spoken the most and toward the one who had spoken the least. And in that shift, the foundation of certainty that had supported the earlier arguments was no longer stable in the same way it had been at the beginning of the session. The courtroom reconvened after a brief recess with a noticeably different atmosphere, one that no longer carried the steady rhythm of controlled narrative but instead reflected a quiet recalibration of uncertainty, as if every participant had returned with a slightly altered understanding of what the next sequence might reveal. Judge Alan Whitmore resumed his position with measured composure, but his attention now carried a sharper focus toward the document that had been introduced before the break. Laura Benson appeared more restrained than before, her earlier confidence now replaced by careful observation, as though she was no longer guiding the case but assessing it. Melissa Reynolds sat upright, her expression composed but no longer certain, her eyes occasionally shifting toward the document that had disrupted the previous flow of proceedings. I remained in the same position as before the recess, hands steady, posture unchanged, because nothing about the situation required adjustment from my side, only continuation of timing. When the judge signaled for proceedings to resume, Laura Benson attempted to re-establish structure by referencing prior exhibits, but her tone now carried subtle caution rather than authority. She began to reinterpret earlier submissions, attempting to align them with the emerging context of the new document, but the coherence she had maintained earlier was no longer as stable. Melissa finally spoke again, but her voice lacked the earlier certainty, instead focusing on clarification rather than assertion, as if she was now seeking reinforcement rather than delivering conclusion. Judge Whitmore, however, did not engage with either interpretation immediately. Instead, he returned to the document that had been submitted before the recess and reviewed it in full silence, his attention uninterrupted and methodical. The longer he read, the more the dynamic in the room shifted, not through reaction, but through absence of interruption. Laura Benson noticed first that the judge was no longer tracking verbal framing but instead focusing entirely on written content, and her posture subtly changed as she recalibrated her approach. Melissa's expression followed shortly after, tightening slightly as she observed the same shift in focus. I remained silent throughout, because silence at this stage no longer functioned as absence of response, but as structural positioning. When Judge Whitmore finally closed the document and placed it back on the table, the pause that followed was longer than any that had occurred earlier in the proceedings. It was not procedural delay, it was interpretive reassessment. Laura Benson attempted to speak first, but the judge raised a hand gently, signaling that he would address the matter directly. His tone remained calm, but there was now a clear distinction in how he was processing information versus how it had been presented. He stated that certain elements within the submitted material required verification against previously provided exhibits, and that this would affect the evaluation of prior claims. The phrasing was measured, but its implication was immediate. Melissa shifted slightly in her seat for the first time in a way that suggested discomfort rather than confidence, while Laura Benson looked down briefly at her notes, recalculating strategy in real time. I did not speak yet, because speaking at this moment would have been premature. Instead, I observed the reordering of attention, as the courtroom moved from narrative acceptance to structural verification. Judge Whitmore then turned toward me and requested clarification regarding the origin and context of the document, and I finally responded, not with elaboration, but with precise confirmation of its source and its relevance to the disputed claims already on record. The simplicity of the response created another shift, because it removed ambiguity rather than adding interpretation. Laura Benson immediately attempted to reframe the document's significance, but her effort now encountered resistance not from argument, but from timing, as the judge was no longer absorbing narrative structure and sequence, but cross-referencing it internally. Melissa remained silent during this exchange, her earlier composure now replaced with focused observation, as though she was trying to identify where the shift in control had occurred. The judge then announced that the court would require additional time to review the implications of the new evidence in relation to previously submitted material before continuing with any further determinations. That statement marked a procedural pause, but its impact was interpretive rather than administrative. As the room began to settle into that pause, I remained exactly as I had been from the beginning, not adjusting, not reacting, because at that point the outcome was no longer dependent on participation, but on verification. And in that verification, the structure that had once appeared stable was now being re-examined from its foundation upward, revealing that what had been assumed as conclusion was in fact only the beginning of a deeper reassessment.